The first case I'm going to call this afternoon is State of Arizona versus Adam Smith, CR 2023-00379.
Sasha Charles on behalf of Dan Noble for the state.
Joe Tobler for Adam Smith, who is in custody to my right, along with me also Alex Rubel.
All right, thank you. And good afternoon, Mr. Tobler. You're new to the case, obviously. I just wanted to make sure before we went forward that you received a copy. Once the court received your notice of appearance, I tried to provide you with a bit of a background as to where we are in the case with a notice of status, just as a notice from the court, outlining a few different motions that are currently outstanding that have been set aside at different times throughout the course of the case, and also making sure that you knew that the case was currently in the middle of Rule 11 proceedings at the time that you came on. Did you get that?
I did. Thank you, Your Honor.
Okay. And at this time, the court has received the Rule 11 evaluation that was generated on the court's own motion after our last hearing. That was generated by Dr. Deborah Pardee, who did a second evaluation with Mr. Smith, and that report, it's dated the 24th of February, but it was filed on March 14th. So I think I'll refer to it based upon the filing date. The court also has received and reconsidered the two Rule 11 evaluations in this case that were generated by Dr. Linsky back on October 16th of 2023 and Dr. Pardee back on November 10th of 2023. Ultimately, the court issued an order for an additional third Rule 11 evaluation based upon the court's inability to conduct a hearing in the matter effectively at the last setting. The purpose of that hearing had been to try to address with Mr. Smith the possible appointment of counsel. As I'm sure you're aware, previously his former attorney had withdrawn, and there was a period of time where the court hadn't received any notice of appearance from any other attorneys. So I became concerned that perhaps he wasn't retaining counsel, so I had set a hearing to make a determination as to whether or not appointment of counsel would be appropriate. At that hearing, he was expressing that he wanted to represent himself, if I understood correctly, but he also was making numerous concerning statements and concerns about myself being a member of the Knights Templar and a Mason.
Ordo Templi Orientis.
And other things that I have no knowledge of and aren't a part of. But the main thing was the court just couldn't conduct a hearing effectively because of his behavior in court. So I issued, on my own motion, I did an order for a third evaluation. So that's why we're here today, because that evaluation's been generated. Did the state receive that?
I believe so, Your Honor.
Okay. And so that most recent evaluation opines ultimately that Mr. Smith is not competent but likely restorable within statutory timeframes. So I wanted to inquire of both parties as to how you wish to proceed at this point. I don't have a preference as to who weighs in first. If you'd like to go first, Mr. Tobler, that's fine.
Thank you. I did get the report and supplied it to the court and also to Mr. Noble for the state. What I want to do at this point, because there's been two findings that he's competent before this, and now this finding that he's incompetent, we want to challenge that. He does not want to be in restoration proceedings. He very seems to understand the process when I've talked with him very clearly, and so we want to challenge that. What we're asking for today, Judge, is either if the court will appoint someone else to do another evaluation. I don't know how the court counts these out at this point because I think the other two are maybe a year old. If that would be that now there's three reports, or if the court sees this as a first report after a year of him being found competent. But either if the court will appoint someone to evaluate him, then we would like to go forward that way. If not, then we would like some time to be able to try to hire someone to evaluate him, because Mr. Smith does not want to be in Rule 11 proceedings. He's been adamant about, clear about that.
All right. And the state's position?
Well, Your Honor, certainly the defense is entitled to a contested Rule 11 hearing. I think that would be the appropriate course at this point, given that there's been 3 evaluations, 1 finding of not competent but restorable, and 2 findings of competency. I think that would be the best way to proceed rather than asking another evaluation of a doctor who had likely already evaluated Mr. Smith. I don't know that that would be a prudent use of the court's resources at this time. And of course, defense counsel is also entitled to hire somebody to evaluate him, I believe. But the state's suggestion would be moving forward with a contested hearing.
Well, from the court's perspective, if the court were to set a contested hearing, the 2 witnesses that the court would hear from would be Dr. Pardee, I'm sure, and then most likely Dr. Linsky, the other doctor that did an evaluation back in November of 2023. Both of those doctors, this court, this division, I do all of the competency proceedings for Coconino County. So all of these cases ultimately get filed in my division, whether they start in one of the limited jurisdiction courts or a different division of the Superior Court. What would ultimately happen is that I have those 2 doctors here. Dr. Linsky, competency is fluid. And a person would be competent at one time and then slip into not being competent and then go back to being competent again. That's something that changes. The reports and the doctor's opinions as to whether or not Mr. Smith was competent back in November of 2023 is not really the issue at this point. Now the issue is Mr. Smith competent right now?
Yes, I am.
One evaluation that the court has at this time opines that he's not competent right now and that he's delusional and suffering from a number of degrees of paranoia and other things. What I do think would probably be appropriate at this point would be to have Dr. Linsky do a fresh evaluation of Mr. Smith so that if that's what the defendant's asking for, that whatever opinion Dr. Linsky has of the defendant's competency would be based in reality in this time, because this is the time that matters, not November of 2023. So I'll grant the request of the defense and I'll order a second Rule 11 evaluation. There's a specific list of providers that the court can have. One of the primary and most used source of those is the Guidance Center. I'll specifically order that Dr. Linsky be the doctor to do the second evaluation. And as soon as these, what will be the 4th evaluation, and I realize it's 4 evaluations, but frankly, it's certainly not unprecedented to have multiple evaluations in a complicated situation. So the court will order a second evaluation be completed by Dr. Linsky, but just for clarity is actually the 4th evaluation total.
Objection. Dr. Linsky has a conflict of interest with Victim Witness Services Northern Arizona.
Sorry, Judge.
Go ahead.
I don't want to interrupt, but Mr. Smith feels that there is a conflict of interest with Dr. Linsky. He's asking if there would be another evaluator that we could use. I know the court mentioned that the court relies mostly on the Guidance Center for experts. I think the actual conflict that he has identified is with the Guidance Center. Is there, are there doctors outside of the Guidance Center that we could choose from?
I don't think that his belief in there being a conflict necessarily is based in reality. He also thinks that I have a conflict of interest in the case and has filed numerous pleadings to this court, which I always return without even reviewing. I treat them as ex parte communications, but I'm aware that they exist, and the doctors have mentioned those in their reports. And he's made numerous similar pleadings to the Court of Appeals to that effect as well. If you can tell me what conflict of interest truly exists for the court to eliminate that provider as a possibility, I would consider it.
Rachel Walensky for loss of illicit income, and now they're trying to cover up the fact that Mark Anthony Clanton is acting corruptly in this matter.
The Guidance Center paid Rachel Walensky.
No, the Victim Witness Services did, but Victim Witness Services are in partnership with the Guidance Centre, plus they're both on the payroll by Health and Human Services, the same payroll who bankrupted.
They're different agents, they're different organizations entirely.
So, yeah, it's,
He's referring to Victim Witness Services, I
Correct, Your
believe,
Honor.
and it's the Guidance Center, which they're different things. One's a block from here, one's miles away from here, and they are completely different services that are provided at those two places.
thank you, Honor. One other thing that we had was, I believe my staff sent over to you and the state, a request for him to be found indigent for provision of services from the public defender.
And I did see that, and I didn't rule on it. Previously, he's been deemed indigent, I think, because he's previously been appointed to the Public Defender's Office, the Legal Defender's Office, and then was reappointed to the Legal Defender's Office just before you filed your notice of appearance. So if I understood correctly, you were just asking for him to be deemed indigent, which I believe I can just take notice of this even before I have the avowal from him as to his finances, which I would have concerns about if he's in the middle of competency. But if you're just wanting the court to opine that he's indigent, the court will just take notice of that. And then if you want to make a filing for specific monies to be released for the use of experts, et cetera, notice the Legal Defender's Office, who typically distributes those funds, that would be the appropriate way to do that at this point.
Very good, thank you, Honor.
All right, anything further?
No, Your Honor.
Not from defense, Your Honor.
The court will order a new hearing just as soon as we receive that additional report from Dr. Linsky, and we'll proceed at that time.
Thank you, Honor. And be excused.
You are excused.